Mickey Truth Girl. Who qualifies her to put a work on these people?
What's up, y'all? It's your girl, Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment, educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So let's get it. All right, y'all. So I actually thought we was done with the Take Capone content. Okay. I dropped a video a couple weeks ago. It was more so just verification. You know, everything had been out for a while. Now, I showed y'all in that video that I submitted the FOIA request like I do anybody else that I run content on, because you know I get my work directly from the source. Although, like I told y'all in that video, Shirexology, shout out to them already. Actually, I already had the police information out there. So, with that being said, remember it was directly for Take Capone, not C-Day or Rondo. Okay. With that being said, allegedly, right? Take Capone responds on YouTube. He replies to some comments. Now, I know it's blurry. I had to kind of like, you know, blow it up. But I'm going to read to you what it says. It says, then it's like you trying to troll me or something at the same time. I never ate no fucking McDonald's. I only smoked cigarettes out of boredom. Oh, okay. Well, according to the documents that I received from the Cook County State Attorney's Office, as you can see in the video I dropped in, as you can see now, it does say redacted states he was given food and drink to eat, including a cheeseburger and french fries from McDonald's. Redacted also drank a Pepsi. So, again, I mean, you can go get the unredacted version. Now, this is what I want the YouTube universe to understand, or anybody. Any paperwork that's allegedly, right, in your name, you can go retrieve it. So, for example, why not? Because to a certain extent, Take Capone could be considered a YouTuber, right? I'm not sure if he's actively still doing YouTube. However, he has a channel, I believe. He could, how about this, do a vlog of you going to Cook County State Attorney's Office, requesting your records live, right? That could put it dead to the air. When they give you your paperwork, see or show us in real time what the paperwork look like, what it says. Don't edit it in real time, live, not a video, live. You can clear it up. Now, the next part is, and I got any court audios and papers. I can see and hear whatever I'm saying is to be said or not said. Y'all reporting on this case be so Rondo got told on crazy. Why y'all bloggers don't be saying what's going on for real with their case? Do y'all know who telling or being accused of telling between the two? Or y'all don't care? Ooh. Now, I will say this. Why haven't Take Capone, you know what I'm saying, dropped this so-called audio and paperwork? This has been going on, what, for about 10 years now? Now, right now, it's about Take Capone. Now, clever. Take Capone. Somebody clip this and send it to Take Capone. You clever. You're very smart. I ain't gonna cap. Because when I first read it, it ain't dawned on me until I went back to the paperwork. It's no audio to what you said. And there's no per se handwritten statements, right? Where you can, like with Soldier Boy thing, that's his handwriting. Because the statement was typewritten. And as it said right there in the paperwork, that he was given two options: video recorded statement or typewritten statement. And he chose, hey, typewritten. I don't want to be on no video. That was smart. Because now it's a deflection. You ain't got no audio of me. You ain't got no video of me. No, we got typewritten paper with your signature on it, though. How you explain that, though? Oh, let me guess. They force you to sign it. Now, Courtney Ely, a.k.a. C-Day. One thing that was not in my video the first time was the appeal paperwork for C-Day. I referenced Rondo's appeal paperwork because that's what Vlad TV put out in response to the snitching allegations with Take Capone. However, I went and, you know, anytime somebody try to deflect, like I'm putting out fake work on them, although I did request on my YouTube, I tagged Take Capone because I wanted to actually do a live with him. He ain't responding. You know, must not be in in the algorithm for him to respond on my page. But anyway, I'm just like, anytime it's a discrepancy with paperwork, I'll go paperwork for paperwork anytime if I do content on you. But nevertheless, so I went looking because I'm like, it's no way. It came directly from the state attorney office. Well, I tapped into the C-Day appeal paperwork. And let's just go down. Let's do the timeline. Let's just break it down. Maybe I didn't do a good job the last time. So let's try this again. How important was Take Capone to the case of Rondo and C-Day? For comparison, you guys, Take Capone is the C-Day and Rondo case as Felicia Holmes is to the YNW Millie case. Okay, Truth Team. And we know how important the material witness for the state of Florida is to the YNW Millie case. So that should give you an idea what Take Capone was to this case. The only difference, though, Felicia Holmes got caught before the trial began. Maybe, she probably should have tried to hide in plain sight, but now she got caught. Take Capone told them ring. I mean, that's basically what it comes down to. And I say this because, again, according to the appeal paperwork, okay, and this is C-Day's appeal paperwork, it says the record reflects that starting in July 2015, the state made numerous efforts to locate Carpenter, Jones, and Brown to subpoena them as material witnesses. From July through December, at least 8 unsuccessful attempts were made to locate and serve Carpenter. On December 8th, on state's motion, the trial court declared him a material witness and ordered any law enforcement officials who located him to bring him before the court. Hey, before the court. I'm just saying, told and ran. But what I found on my research journey is that, shout out the Chicago Tribune, okay? They send you 100,000 emails a day, but for $1, you can see all their articles. And this one in particular from March 3rd, 2016. And it says, appeals court hears emergency motion on jailed witness and rapper's murder trial. Now, no. It's not about Take Capone. Not the title anyway. However, if you read that same article, this is what it says, okay? It says one alleged eyewitness, also a rapper, allegedly tore up a subpoena when investigators finally found him before fleeing to Atlanta days later. Now, that could be anybody, right? Anybody. I know y'all gonna say that could have been this person, that person, that person. You right. It could have been. However, in Take Capone's statement to the police in 2014, and this is directly from the state attorney's office, if you pay attention, this male witness here has a rap name. Okay. I know y'all probably like, still not piecing together, Mickey. Still doesn't make sense, but we're just getting started. Let's continue. Take Capone was served and went to Atlanta. How do you know that, Mickey Truth? Well, in C-Day's appeal paperwork, it says Ely does not challenge the materiality of Carpenter, Jones, and Brown to the state's case. And for those who don't know what that word is, because I probably said it wrong, but it's important. They're important to the state's case. Nor does Ely challenge the truthfulness of the state's representation regarding the efforts it took to secure those witnesses. Instead, Ely argues that there was no reasonable grounds to believe that Carpenter's testimony could be obtained, and the state did not show due diligence in locating Jones and Brown. Both contentions lack merit. With regard to Carpenter, Ely makes a conclusory statement that it was not surprising that the state could not find him since after being served, he traveled to Atlanta, Georgia. Let's continue. But as the state explained to the court on January 22nd, and again in its motion for extension of time, okay, extension of time, United States Marshals, the FBI, and Atlanta law enforcement were all searching for Carpenter. Under those circumstances, it was not an abuse of discretion for the court to find reasonable grounds to believe that Carpenter's testimony could be obtained. They were looking for him. They were looking for him up high. They were looking for him down low. They were looking for him in Atlanta. I mean, the FBI was on his trail. Okay, you got to be a very important person for that. You know what? Felicia Holmes had all that going on too. Let's continue. Now, to the truth team, because some of y'all may not be familiar with this case. Mariah Hamilton was found before Felicia Holmes in the YNW Melly trial. Would they still need Felicia Holmes? Y'all let me know in the chat. Because it's answering, good, would they? Not if the clock for a speedy trial was against the state. And for those who care to know, you can look it up yourself, but that is the Illinois speedy trial notion, okay? Capone issued a warrant for contempt of court. On December 28, Brown appeared in court for trial, but Carpenter and Johns had not yet been located. The trial was continued on the state's motion to January 15, 2016. Okay, I'm just saying. Y'all get where it's going. They held up the trial, okay, to try to find Carpenter and Johns. Okay, now, by January 15, Johns had still not been located. Carpenter had been located and served, but neither he nor Brown appeared in court. On the state's motion, the court issued rules to show cause against Carpenter and Brown and also issued warrants for their arrest. Trial was rescheduled for January 22nd. Now, again, I don't know about y'all, but you should know contempt of court is when you don't show up, okay? Some states call rule to show cause, but, you know, means the same thing. For those who may not understand what a material witness is, it's a witness who possesses information going to some fact that affects the merits of the case. So, like I said, important, okay? Now, like I said, speedy trial is important, right? So, the speedy trial period was set to expire February 17th. But they can't find old Carpenter, a.k.a. Capone, okay? Or Johns at that point, right? Or, remember, Brown even skipped out after coming forward the first time. On February 1st, the state moved for a 60-day extension, citing its continued inability to locate witnesses and detailing its unsuccessful efforts to obtain their appearance at trial. Again, compare it to YNW Melly case. The witnesses they've been trying to locate and they couldn't locate. It's just been delay. Now, if you go down to where the arrow is, it says after the extension was granted, both Johns and Brown were taken into custody and a case proceeded to trial on March 4th without Carpenter, though. Okay? Just keep that in mind, without Carpenter. Shout out to Ratbirds for allowing me to use their obtained police report for none other than Jamonte Carpenter, arrested on March 5th, 2016. Okay, now, Capone had multiple charges that day, but the only one that's, important to this video is the last one, which is the issuance of warrant, meaning a bench warrant or an outstanding warrant. Not sure the terminology they will use in Chicago. However, it was a warrant, right? And it also gives, guess what? The time, the date, all that. But one thing in particular, and I know it's blurry, right? At the top, that's the date that the warrant was issued, okay? January 19, 2016. So, Capone could go request his own arrest record. Will he have an arrest? Or will he ever have, no. Will he have an arrest on March 5th, 2016 from the Chicago Police Department, where he was also picked up for a January arrest warrant? He could show us that easily. We're going to continue. And I'm actually going to blow up the bottom part. We need to look at that. So I hope this is a better vision for you. And we're not going to get into everything, but just at the beginning, it says this is an on-view arrest of Gang Investigations Division Squad 6510. AOs have knowledge of aforementioned warrant for contempt of court and investigative alert Then it gives a number. AOs had information that the arrestee was at a recording studio located at 232 East Ohio, right? Okay. So if you fast forward down a little bit, right? The offender was placed into custody. So he went to jail that day. Now, after he was Mirandized, the offender stated, I have the pistol because my own people are on me. Arrestee is a documented Brick City Black disciple. And then redact some stuff. Now, I just want to say this. Why would they be on you? Like, that's crazy, right? Now, Capone was arrested the day after court. Well, after trial began. Who could give the same info if Capone runs after telling, right? Who can still get it? Because at this point, once trial started, hey, he was still on the run. Brown and Carpenter could testify to the same information. You know why? Because if you look at C-Day appeal and Rondo appeal, it both says that Brown heard allegedly C-Day's voice on the phone because it was on speakerphone after Capone made the call. So that matches up. And before I continue, if you go back and read the statement provided to me from the Cook County Attorney's Office, State Attorney's Office, and the Rondo appeal, even C-Day appeal, a lot of that information matches to what, guess who? The girl with the last name Brown said. Just saying, if you want to, it doesn't matter. All right. So, this is my question. Brown had previous statements with the police, and she was a material witness. Also, Johns was a material witness, had previous statements that actually they used, as we learned in Rondo's appeal, used to impeach her because she said one thing in her statement and got to trial and said something else. So all other witnesses had prior signed statements except Capone. 3 material witnesses, 2, right, allegedly, according to Capone, had previous statements but him. No. All 3 had previous statements, including him. That's why they were material to the case. Now, if you never said anything, how do they know what you know? How can you be called a witness without making a prior statement to know if you are useful in the case? Like, come on now. Every trial, just take a look. And since we've been using Melly case as an example, every witness that has gotten on that stand has made prior statements to the police, has provided a deposition to the police. Am I right or wrong? Or am I tripping? Capone provided a statement to the police for whatever reason. That's not up for debate. What the reason is, that's on him. However, he did not testify at trial. He ran. But although he didn't testify, you pointed out a shooter according to this statement that you chose them to type up for you. You called names. You did all that in the statement. It doesn't take away the fact, although you ran from it and said, oh, no, I'm told, but I take my telling back. Don't work like that. But again, that's just my opinion of how you look at it. Maybe if you ask, say, for example, C-Day, he may not see it that way because maybe he was able to redeem himself by not showing up to court. I don't know. But it doesn't take away the fact that you told. You gave a statement. So, case closed, Truth Team. There's nothing left to say in regards to this situation. But the proof is here. Now, again, as I say in every video, any conclusion that you draw is on you, not me. But the facts are the facts, and my opinion is case closed. Make sure you like, comment, share, subscribe, tell a friend to pull up on your girl, Mickey Truth. And as always, go to MickeyTruth.com and get you that merch because you know your girl stay with that work. So until next time, hello! You rappers ain't safe. No matter what you go through, do what you got to do and conquer the world.